she sued her own sister. For $3,200, the judge left everyone speechless. She sued her own sister for $3,200, and when the judge finally spoke, not a single person in that courtroom saw it coming. For 11 years, the two sisters had shared everything: holidays, secrets, phone calls that stretched past midnight. But when a marriage collapsed and an apartment stood between them, something older and more fragile than any lease agreement was put to the test. The plaintiff had been married for 6 years when her husband asked for a divorce. With nowhere else to go and a 9-year-old daughter in tow, she called her sister. The defendant, who had recently signed a 12-month lease on a 2-bedroom apartment in the same city, agreed without hesitation. She'd take the back bedroom, her sister and niece would take the front. They'd split utilities, no written agreement, just family. What nobody accounted for was what grief looks like when it moves into a shared space. Over the following 8 months, the dynamic shifted. The plaintiff, deep in divorce proceedings, struggled to hold herself together. Dishes piled up, a bathroom fixture was cracked and left unrepaired. A door hinge, apparently pulled too hard in a moment of frustration, came partially off the wall. The defendant later testified that she brought these things up twice, gently, and was met with tears and deflection. She stopped pushing. She was, she said, trying to be a good sister. When the lease ended, the defendant received a move-out inspection report and a letter from the property management company. Of the original $300 security deposit, they were returning $410. The remaining $2,709 was withheld for cleaning, a replaced vanity fixture, door frame repair, and full carpet replacement in the front bedroom. The defendant forwarded the itemized list to her sister and asked carefully if they could talk about it. They did not talk about it. Instead, 3 months later, the plaintiff filed suit in civil court, claiming her sister owed her $1,600, half the destroyed deposit, on the grounds that the living arrangement had been a shared tenancy and therefore shared liability. She argued the damage was ordinary wear and tear, that the management company had grossly overcharged, and that her sister, who had a stable income and no legal fees mounting on her kitchen table, was better positioned to absorb the loss. The defendant countersued for the full $20,090, producing the itemized inspection report, dated photographs taken by the property manager, and a written statement from the building's maintenance coordinator, confirming that the carpet in the front bedroom required complete replacement due to staining that predated the building's standard 10-year depreciation schedule. She stood in that courtroom and said quietly that she had opened her home during the hardest moment of her sister's life. She had not expected a bill for it. Both women cried at different points during testimony. The courtroom was very still. Then the defendant's attorney submitted a document nobody had thought to mention until that moment. A text message exchange from 4 months prior to the move-out, in which the plaintiff had sent a photograph of the bedroom carpet and written, "I am so sorry about this. I'll figure out how to make it right." The defendant had replied, "Don't worry about it, family." The plaintiff had responded with a single word: promise. The judge studied the thread for a long time. Her ruling was not what either side expected. She declined to award damages to the plaintiff entirely, finding no legal basis for the sister to absorb costs tied to a tenancy the plaintiff had never formally joined. But she also declined to award the defendant the full $2,709. Instead, she ruled that the text exchange represented an informal acknowledgement of liability on the plaintiff's part, and that the defendant's reply, "Don't worry about it, family," constituted a partial waiver of that claim in the spirit of the exchange. She awarded the defendant $900, representing the documented cost of the door frame repair and vanity replacement only, while ruling the carpet claim had been emotionally waived in the correspondence. Neither woman looked satisfied. Neither woman looked at the other. Outside the courthouse, a mutual friend who had attended the hearing said the two sisters left through separate exits. The plaintiff filed no appeal. The defendant cashed the $900 check 8 weeks later. As of the filming of this account, they had not spoken. The judge's ruling was legally narrow but humanly precise. She found, in essence, that a promise made in grief is still a promise, and that grace, once offered, cannot always be taken back in court. Which raises the question that lingers long after the gavel falls. When someone opens their home to save you and it costs them something, what do you actually owe them?